Good afternoon, everybody, and welcome back to Behind the Veil. I am so excited to have you guys back with us. And so my name is Keith Willard. I'm your host, and I created this little show, I can't believe 19 episodes ago, as a way to help couples navigate planning during this age of COVID. Now, when we first started the show, and I say we because I have a panel that has been with me since the beginning. When we started this show, it was really simple questions. You know, the questions that you should ask your florist. What should you anticipate when talking to hotels? Meal planning, guest counts, invitations. Really simple subjects that, you know, we wanted to make sure people had some advice on, because 90% of the couples here in South Florida don't have an event professional attached with them, meaning an event planner or somebody else in this planning field. As we've gone through these shows, we've realized that the subjects that we needed to talk about were much broader and sometimes a lot more difficult than we ever anticipated. And that includes today's show. Today's show, we're going to be talking about contracts and estate planning. I know it sounds a little dry to think about contracts and estate planning, but more than ever, it is important to protect yourself and your loved ones, because you never know when the worst case scenario is going to happen. And contracts, you know, before, it's kind of like the Apple contract where they say, click here and I agree, and nobody reads through that contract. Well, all of a sudden, COVID hits. And then all those subjects and terms that we signed off on so easily have become an issue. And so now we're going to talk about those subjects, and we're going to make sure that you know what to look out for. And then also estate planning. Why estate planning? Well, again, during the age of COVID, many couples have moved their weddings. And specifically, we had a couple that moved their wedding, and a story, not my particular client, so I should just say that, that moved their wedding from this March to March of 2021. Unfortunately, during this time, the groom caught COVID and passed on, and the bride, unfortunately, is not legally allowed, but she basically gets nothing because they're not legally married. And so unless there were some wills or some type of paperwork or legal documentation in place, she's basically out with nothing. And we want to make sure that you protect you and your loved ones during this age. So yes, today's subjects are a little dry, but we're going to try to juicy them up, so to speak, and that they're more relevant than ever. So let's just dive in. And first of all, I'd like to introduce our panel. Our first is Marcy. Marcy is the owner and Affair to Remember by Marcy Gutenberg. It is great to see you, Marcy. She is our invitation and editing specialist. I'm trying to say something.
Hey. Etiquette. Etiquette. Thank you for having me again today. I love being here with you on Tuesdays. You know that. It's a wonderful day.
It's awesome to have you, and today's subject is even crazier. Also, I'd like to welcome Tyler Black with Cachet Events. Hi, Tyler. It's nice to see you again.
Hey.
So Tyler is our decor and florist expert, and so he is all things when it comes to events. He does events from 30 people to several thousand, from here to Las Vegas. It's great to see you again, Tyler.
Hey, good to be here.
Hey.
No emergency rooms today.
No emergency rooms. Last week, unfortunately, Tyler was not able to join us because 5 minutes before the show, one of his workers ended up cutting himself, and he had to take him to the emergency room. So it's good that you don't have that kind of happening today. Next is Katana Kaplan with a gallery of amazing things. Katana is also an event planner and has recently fulfilled several weddings over the last 3 weeks, right? You've had a wedding every week for the last 3 weeks? Oh, and I've got her muted. That's my fault. Sorry about that.
And
Let's do that.
Just so you know, I'm sitting in the soundproof area right now. Oh. So I'm hoping, let's test it out. You know, they have all that work going on over there. So I'm going to be their first guinea pig test event. This behind me is the soundproof walling. So let's test this out.
So Katana, if you can't tell, Katana is with a gallery of amazing things, and they're going through a massive reconstruction. So she's moved herself into a soundproof area so that way she can still talk, and I don't have to mute her every time. I'm so sorry about that. I totally did that. Next, I'd like to welcome Brooke Stoner. Hi, Brooke.
Hello, everyone.
So Brooke is actually going to be doing her own podcast starting Thursday. What?
Awesome.
I know she's very nervous.
With that.
Yeah, I know. She's very nervous about it, but I think it's going to be awesome.
I strenuously object.
Well, I've been kind of pushing her because I'm like, you need to do this because
actually, I thought I was helping you do yours, and this was like blackmail for the money I owe you. But apparently, we're running a new mob here in Florida.
No.
So, I guess it's gonna be my show. I'm fine with it.
Totally your show and not ours. Okay.
Well, and he can't mute me, so hey.
That's true. That is absolutely true. So now I'd like to
introduce Tyler.
Hello, Brooke.
So now I'd like to introduce our special guest. Our first special guest is Paul GrijAlva, who is a contract lawyer who has an education. His education is he got his bachelor's from the University of Arizona. He also got his Juris Doctorate from the St. Thomas University School of Law. And then he got his Master of Law in Intellectual Property from the Santa Clara University. His experience is that he was a former business operation counsel and senior manager contracts administration for the University of Miami. And currently he is the director of contract services for Pima College, as well as his own law firm. But his entire practice is focused on transactional, meaning contracts, and intellectual property, which makes him perfect for today. He began and implemented the contracts administration department at the University of Miami, was the first senior manager of contracts administration at the University of Miami as well. Hi, Paul. It's great to see you.
Hey, thanks for having me on. It's great to be on with you all.
And I should say, in full disclosure, that I actually was the event planner for Paul's wedding like 10 years ago.
Yeah, well, 2014, and before that, you actually planned my law school's barrister ball, and that's how we met.
Oh, that's right. That's right. I was like, oh yeah, Barry University. I totally forgot. Was that right? Yeah, Barry University. That's funny. That's been a long time.
That was probably a very good party then, if you got
It was amazing.
It was an amazing. It was an amazing party. Had some last minute issues as all things, but anyway. I'd also like to introduce Christine C Gill, who has been practicing law in Florida for 26 years. Christine received her bachelor's from Southern Methodist University in 1989, her law degree from Cumberland School of Law in 1992, her LLM in taxation from the University of San Diego in 1993. She has worked in the trust department at SunTrust Bank and worked serving the elder community before entering private practice. She has been in private practice since 1999, so she is obviously well versed. While most of her law practice is situated in Broward, Palm Beach, and Miami-Dade counties, she has practiced in multiple counties throughout Florida. Christine is married to Sean. I know this personally, and has two daughters, Mary Elizabeth and Megan, who are just amazing. You have the most amazing kids. Hi, Christine. It's great to see you.
Nice to see you too.
Yay! Welcome.
Yay.
Welcome to the show.
Excited. I feel like I know all the panelists because but I didn't know what everybody did. So, and Marcy, I love etiquette. So,
right.
Very good.
She didn't like me very much.
Yeah, thank you.
And then finally, we'd like to welcome Wendy Ennis Volcy, a graduate at the University of Miami Law School. She has been practicing law for 29 years. She also has a background in finance and is a registered nurse. Hello. Before going to private practice, Wendy was in the House Counsel for North Broward Hospital District. She has been practicing with Christine for the past 13 years and handles their clients' litigation. Wendy, no small task, man.
No, but I enjoy working with Christine, and it's been a fortuitous what do I even say? A fortuitous right.
Like a collaboration?
Relationship. It's been a fortuitous relationship, really. It was a fortuitous meeting, and it's been great ever since. So.
She's my other spouse, my daytime spouse.
the work spouse.
Your work husband. So let's jump into this, because a lot of people are trying to figure out, why should we even be talking about contracts and estate planning? And again, you heard my little intro about what's going on in the world. And so, to be honest, Paul, why should people be worried about contracts?
They should be extremely not worried, but focused and centered on the contract, because when you're planning an event, there are numerous contracts you sign. You think about it. You have the venue. You have a number of vendors. You've got just a number of different contracts you have. And those 4 pages of that, or those 4 corners of that document really set up, protect you in the event that something goes wrong. For example, let's say I want to reschedule or something or cancel.
Right.
If I'm not thinking about these other little things, I could be out $5,000. I could be out $10,000. But if I set the contract up correctly and we negotiate it correctly, then I'm able to protect myself.
Yeah, to protect yourself, because a lot of times people don't understand that contracts, it's the nuances in the contract that actually make the biggest difference when it comes to renegotiating, moving the date, even canceling. Unfortunately, you got to make sure those terms are spelled out in that contract.
100%, Keith. I mean, for example, my wife and I are both attorneys, and we just graduated law school when we were actually planning our wedding, and we ended up pushing our wedding back a year. And this was before I'd actually really gotten into my line of work. And had I been doing what I do now, I would have saved some money, because one of our vendors charged us a rebooking fee, and they stuck to that. I mean, thankfully our other vendors didn't, but one of our vendors did. And we were at $500. So those are kind of little nuances that if you negotiate at the beginning, you're not going to have to worry about that later on. So, I mean, and there are a number of issues, but just kind of the big issues that always pop out into my head are cancellation, rebooking. And then there's other little nuances within that as well, such as, a tiered approach. If I cancel 6 months out, I get my full refund, or if it's 30 days or 2 months out, and then a tiered approach down. There's also rebooking.
Right.
And another thing, when we just were having my daughter's birthday party, we had it at a venue here in Arizona, and something that in Arizona, as in Florida, in the middle of the summer, it rains. So it's actually more expensive to have the event outside than it was to have it inside. But when we were negotiating that agreement, I put a clause in there that stated, if the event has to move inside, we're going to get a refund of some of that money. So those, thankfully it didn't rain, but those are little issues that you need to kind of think about at the outset. So,
Oops. Right. So I've actually, and I've said this to a lot of my clients, it's like, talk about your budgets and your contracts at the very beginning, so that way you can get that mess and that stress out of the way and then focus on the joy of planning. It's important to think about the nuances first, not later, because you got to do that research. You got to really focus in on making sure that you're protecting yourself. Now, we're not saying that we want to try to take advantage, because contracts are really protection for both parties, both the vendor and the client. So it's important that you protect yourself, but also the hotel has a team of lawyers that is making sure that the hotel is protected as well. Yeah. So let's talk about estate planning. I mean, really, we're in the joy of planning our wedding. Why should I be concerned about estate planning? I mean, Christine,
yeah, when Sean and I were planning our wedding almost 21 years ago, the last thing we were thinking about is estate planning. But we probably should have, because if something happens to somebody before they actually get married, the person could be stuck with nothing, like you said. Or say they buy a piece of property, like real estate, and it's not titled correctly, and the one person dies, you might own half of property with your intended family.
Right.
And I mean, in a lot of cases, hopefully they all get along, but in most cases, when it comes to money, people are going to want their fair share, And if you don't have a will or something, the state makes a will for you. So say your fiance, has parents,
right,
or children from another marriage.
Yeah.
If you don't delineate how this property goes, you might be sharing with people that you don't want to share property with.
Well, and I get that, because as a gay man,
Right.
when I was growing up, you would hear these stories of couples that had been together for 20 years, and because they didn't have any documentation in place, and now this is happening with heterosexual couples as well. If you don't have any documentation in place, the family can come in and take everything, because there is no legal rights before you're married. Am I correct in saying that?
That is correct. That is correct. And if you don't title things correctly and have wills and other estate planning documents, say you even get sick and
Right.
you're not married, somebody other than your spouse, you might want your boyfriend or girlfriend to be handling your financial or medical affairs, and they can't even come into the hospital. We've had a lot of that with same-sex couples.
Right.
And but it affects heterosexual couples too, in that until you're married, and even when you get married, if you don't have a will, the state of Florida or wherever you are makes one for you, and it might not be what you want it to be.
Yeah, 100%. So
Yeah.
let's talk about the. I'm going to go back to contracts. So because we're talking about planning and that whole love affair. I just said yes. I'm ready to start my wedding planning. Paul, what are some basic tips that people should arm themselves with when walking into, let's say, a hotel for the first time? What should they be looking out for on their contracts?
Sure. And the first piece of advice is I would say don't walk into the venue and sign the contract on first glance.
Oh, yeah.
Read it. Have somebody who's experienced in this area read it specifically. Because, again, never take it home and get the opportunity to read it. But, like I said, and I kind of touched on this a little bit prior, the biggest things you're going to want to look at are cancellation and rebooking clauses. Because that's where, at the end of the day, a big thing is money, right? Especially planning these events. You want to see how you're going in the event that you have to cancel or rebook. You don't want to lose out on a lot of money. Another thing is the alternative venue, because, like I said, a lot of people want to do stuff outdoors. Sometimes that may not be available due to weather.
Right.
Big item right now, especially in today's climate with COVID and social distancing, is force majeure clauses. Force majeure is huge right now. And I've seen a lot of vendor contracts where it's just one way, where it protects the vendor. So that's got to be mutual. And for those who don't know what force majeure means, it essentially means that the parties are relieved of their duties in the agreement with what's called an act of God. But it's been expanded upon to include now almost every force majeure clause now has a pandemic out or some kind of other just pandemic, epidemic. And that's very, very important right now, because I know one of my clients who they didn't come to me before they signed their agreement. They signed an agreement. The force majeure clause was one way, so they're facing the potential of being out their whole deposit because the force majeure clause didn't go two ways. And other little things that people, especially when I was planning my wedding too, I didn't think about this, but these are things now that I do this every day, are liability clauses. And this is both ways: liability to protect the vendor and liability to protect yourself. And such as over serving of alcohol or things like that you don't want God forbid one of your guests, something happened to them, they come back and sue you. And those are just indemnity provisions. And also too is rights. So you want to make sure that the venue and the performer, whether it's a DJ, a band, or whatever it is,
Well, one of the things that I think comes up a lot in my world is rights to the photographs from a photographer. And I think I'm looking at Katana and Marcy. We're all kind of shaking our head. Yeah, because, you know, we run into this issue where the photographer says, they put it in their contract that they have the right to reproduce your photos for their advertisement, for their Instagram, for the social media. And sometimes people don't want their photos kind of out there for the just in case. The other side of that is sometimes they only give the rights to the edited photos, which I kind of understand, to the client, you know, to the couple. I mean, is that something that, you know, you've run into, that you've heard talked about?
Yes, very, very much. Copyright's a big thing with photographers. And, you know, my experience with that is it's in their boilerplate. The photographers will always put that in there, that they own the rights, that they own the rights in the photos. They'll essentially give you a license to reproduce so that you can have the photos, and you don't actually own the rights in the photos, but they'll give you a license. But my experience is that that's just boilerplate. They're going to put it in there, hoping that somebody misses it.
Doesn't notice it. Yeah.
Exactly. But, you know, every single one of those I've been able to negotiate where the rights are actually it's a work for hire, essentially, so that the rights are so if I'm the client, I own the rights in the photos. Now, if I want, I can give the photographer a license to use one or two pictures with my prior approval, but that's up to me. So again, and that's all negotiable, and most of the time the photographers will be okay with that as long as they have something to be able to post for their own advertisement, and you essentially can negotiate prior approval for that. But I have yet to be in a situation with a photographer where they don't just go ahead and fully assign the rights over if you try to negotiate that with them.
But that's the thing, is that you actually have to ask for it before they do it. And you know, again, it's like not checking off like the Apple Play where you just look, you know, you don't even look at the contract, you just breeze through it. So question for Christine and Wendy. You know, typically couples nowadays own property together before their big day. They've bought a house, they've bought a condo, they've bought cars together before the actual wedding. If it's bought in both of their names, do they need a will? I mean, even before they're married, if it's joint custody, do they actually need a will to go with this?
Yes, because just because you own jointly, if the magic words joint tenant with right of survivorship isn't in that document, in a like real estate, it's presumed that each person owns a separate share. So you have girlfriend and boyfriend owning property, and the attorney or whoever did the closing didn't put those magic words at the end of it. Right. And girlfriend dies, her estate, if she doesn't have a will, then it goes to, if she doesn't have children, then it would go to her parents.
Right.
It could go to a cousin. It could go to, yes.
Yeah. Whatever happens, the Florida makes, or whatever state they're living in, makes a will for that person. So in Florida, if they don't have children, the next person that they'll look to are the parents. If
so
they
it's not going to the boyfriend or the girlfriend?
No.
It's going to a parent?
It can go to anybody.
Siblings. That's the one that we're getting a lot of, because they don't have children. The parents have died.
Yeah.
And then it goes to the siblings. And then we'll have one sibling who'll say, oh, well, he only liked me.
Oh, very Joni Christina vibes.
Right?
Oh no.
And other people will say, yeah, that's true. He hated his sister, but sister still gets a share. Or if one of the siblings dies, their children stand into their shoes.
Right.
So I'm actually kind of caught off guard by this, because I didn't know that. I didn't know that if you're not married, it's a percentage that you own the property 50-50. And then if somebody dies before you get married, that 50% goes to someone else and is not automatically given to the girlfriend.
It will depend upon the language in the title. So if the title has joint tenants with rights of survivorship, then whoever lives basically wins. Okay, and then you get everything. But if it misses those terms, if it misses that term, then it's a tenancy in common, and that belongs to 50% of the decedent's estate.
And let's just say that there are no like, let's say that the groom doesn't have any family, doesn't belong to anybody. Does that estate then go to the state of Florida?
They're going to find it can escheat to the state, but technically it's going to go to the either the next of kin, or they're going to find somebody, even an extended relative who may not even known this person, or even like this person. So it could literally go to that person, that 50%. So be very careful with your own deeds.
So that could actually go to some random third cousin in North Carolina that has no idea that this person exists. And all of a sudden somebody calls them, or they get a letter and says, guess what? So-and-so died, and you have 50% of their house.
See, little Edie could have fixed up the mansion the whole time.
That's what I'm saying. It's like, and if I'm, no offense, but if I'm that third cousin that doesn't have any idea who this person is, I'm going to take that property.
Oh, yeah. Oh, yeah. I mean, the right thing, and sometimes we have a few people who will do the right thing, but very few. And usually it's somebody who didn't even like the decedent.
That's underneath my head.
That's always how it is.
Well, and I have a question for you. As far as, let's say it was a newly purchased piece of property, and then the person that passes, that portion gets given back to their next of kin, and their next of kin doesn't have the funds to support it. Then who is responsible for that person's payment if that person can't afford it?
Oh, that's interesting.
Well, I think you'd have to probably partition the property, and the person who can afford it would, have the court determine a price, and it's a mess.
That sounds like a mess.
It's a big mess.
Wait a minute, hold on, rewind a second. So if they were in all this huge debt, and it just shifts over to this person, gotcha.
Well, it doesn't happen so quickly. You have to go through a probate process, and with notice to creditors and things like that. You have to wait 3 months for the creditor's period to expire. So
yeah, see, Becky was one of them bad cousins. I don't like her. No.
Yeah,
I'm Brooke with the good hair.
Right? Yeah, Becky with the good hair. Well, Paul, I want you to weigh in here a little bit as well, because let's talk about responsibility for contracts. Let's say a couple has gotten married and they are in a contract with a hotel and one of them dies. Does that mean that the other person is responsible? Especially if they both don't sign the contract. What if only the groom signs the contract? The bride does not sign the contract. Is she going to be responsible for the contract, or does that go to the family?
Well, legally, whoever signed the contract. And so, at the top of the contract, you'll have the parties of the contract. And so if it's just the groom's name, and the groom signed and the bride is not tied to that, then yeah, there's nothing legally tying the bride to that. So it's whoever is named as a actual legal party to the agreement and whoever signed. Now, if they're both signed, they both have their names, and then somewhere in the contract you put language that, you know, the individual signing this agreement represents both parties, then it gets a little bit more tricky. Because then it's like, okay, well, only the groom signed, but up here it's stating that the groom had authority to sign for the bride. I mean, that could, if the bride really says, no, I didn't give him the authority, then you could get into some kind of litigation battle. But I mean, the venue or the vendor definitely will have an argument. But what it comes down to, the biggest thing is who's named as the legal parties at the top, which is going to be party A and party B. And party B is either going to be the bride or groom by themselves or together jointly. And typically, if they're together jointly, I mean, for their own benefit, they should probably both sign it. But if one of them says, "Hey, I don't want to be on the hook," out of this, just you be in it. But I mean, a savvy vendor will have them both be on it, just for situations like this.
I mean, I find that fascinating because, you know, a lot of people don't even think about that. I mean, nobody wants to think about somebody getting sick or dying in the process of, you know, going towards their I do date. I mean, Katana, you're on the vendor side of it. You're a venue. I mean, have you had anything like this happen? I mean, not only about somebody passing away. I mean, obviously there's some cancellation issues as well, like who's responsible if somebody cancels or people break up. I mean, have you had any? Oh, and I think there you are. Have you had any of those instances where you were like, okay, let's work this out?
Recently, we did have, not related to COVID. I did have a bride that flew down from New York. It was a destination wedding, and she signed the contract. The fiance had never been to the venue. She signed the contract, and then about 6 months later, she called me to tell me that he had developed cancer, and and they wanted to postpone indefinitely. We don't want to cancel because we really want to have our wedding there. And I guess, you know, she really wanted to keep up those high hopes.
Right.
And I can certainly understand that, you know, not wanting to give up that dream and saying everything's going to be okay. And when it got to a year and a half that we were still on hold, we were still in that holding pattern, I just called her up, and I had kept in touch with her the entire time and said, Cheryl, I know this is kind of a hard decision, but I think we should just put this off for a while. And she agreed, and we just ended the contract and we just refunded the money. You know, this is one of those things that as a venue, sometimes you have to have a heart instead of just a bank account. And I'm lucky enough to be in a position where I don't work for a large corporate conglomerate where I have to jump through fiery hoops to do things for people. I work for private owners. So it's easy for me to walk up to somebody and say to them, this is the situation. What can we do for them? And for the most part, when it's something like that, which I mean, I was very heartfelt for this one. This was a tough one. And we refunded it. No questions asked.
Well, because you did the right thing. I mean, your venue did the right thing, obviously.
It's a little different though than some of these larger corporates. So I can understand that they have something in place, and they have it in place to protect their money and their date, and they in good faith gave out a date that they didn't resell. So this is where we're at. But
so Paul, given kind of this story, is there anything that can actually be put into a contract that kind of protects people in the case of death? In the case, I mean, obviously there's some cancellation, but I mean, is there anything like because we already talked about act of God.
Or going off to active duty or something.
Right. Or exactly. Or goes off on active duty. Is there like anything that we can advise, our clients about?
100%. I mean, and this would actually all fall within the force majeure clause. And that's why when you see force majeure, you're going to see it's expanded. It's not just the act of God. You see very expansive force majeure clause now that include act of God, pandemic, epidemic. I even include death of a party or sickness of a party that prevents them from being able to kind of meet their obligations. So really, all this comes down to the force majeure, where you put those things in there that relieves the party of their duties or obligations, and then it comes down to the other side negotiating. But right now, I mean, in today's climate, I haven't had any pushback when you include stuff as pandemic, epidemic, death of a party, because you're exactly right. I mean, you don't know what you don't know. So if somebody gets sick or God forbid somebody dies, you want to have that stuff in black and white on the contract to protect you. So yeah, 100%, that stuff would all fall within the force majeure clause.
Wow. I mean, that's like stuff that we probably would have never thought about if it hadn't been for COVID, because obviously, those are kind of one-offs that somebody getting sick or somebody dying is kind of a one-off. It wouldn't be something that you would normally even think about. But I'm glad that we're actually, I'm not glad obviously for COVID, but I am actually glad that we're having this conversation, and that kind of leads me to another question. Like, couples, typically they're young, they're just getting married. A lot of times they don't have a lot of assets in their world. I mean, is it important to have a will, and can you make your own will? Christine, like, can people make their own will, and should they?
Christine's muted. I don't know why Christine is muted.
That's weird. Sorry about that.
Okay, go ahead. Go ahead, Wendy.
No,
you can
sorry, that was totally my fault. Totally my fault.
It doesn't matter. I can box you for it, but we think it's honestly the two of us work together, obviously, and we think it's important for everybody to have a will, regardless of whether you think you have assets now or not. There's going to be a time, we hope, that you will have assets, whether you inherit them or get them created on your own. But either way, and there are things such as wrongful death actions as well. And you want to be able to determine, as you would in your own will, who gets the assets for a wrongful death action, including your fiance, including your, even if you're not married at this point, or even if you're just newly married, who is it you want to benefit from this? And again, a will is not an end-all be-all. It can be changed. And you can change it every 5 years, 10 years, whatever it is, when your circumstances actually change in life. When you inherit something from your parents, when you buy a house, when even if the title is appropriate, as we've discussed before, you want to make sure that who you want it to go to, it gets to, and not Great Aunt Sally,
And actually, I mean, the funny thing is that we have a situation where we have a decedent who just died, and the niece said, "Oh yeah, he did a will and he left me everything." But he did his own will, and it didn't follow the formalities of execution that needed to be followed. So guess what? She has to share with his sister, along with, I think, her sister and some other people. But, what happens is that if you do your own will, if it's not done properly, then according to the laws of your state, then you could be in an intestate situation again. Intestate meaning as if you died without a will. So, so you could write it on a napkin in the bar and, witness it and everything. And if it's not done properly, then it's
void. It's void.
So, wait, you just said something that I find fascinating. You said, if you write it on a napkin in a bar and you sign it, I mean, if done properly, is that an actual will? No. Could that actually be a will?
It would have to.
That's a holographic type of situation. Okay. But usually in the state of Florida, which is where we practice right now, in the state of Florida, you need at least 2 witnesses and a notary. Okay.
There we go.
And you need to have a personal representative designated who is either a family member or a family member living in the state of Florida, or somebody else living in the state of Florida, or a family member out of state. Period. That's it. If you have your best friend who you consider your mother, brother, sister, aunt, uncle, whatever it is, and you put them as the personal representative, and they live in Washington State, that will not go. You know,
because it's different. Because it's a different state.
Because they're not related.
They're not related. There is not.
You might think of them like your cousin, but if they're not, legally your cousin, then they can't serve as personal representative.
That's crazy. That's just crazy. I mean, this kind of leads me to,
you can have all of my nothing.
Right. You can have all of my nothing. You can get all my debt. You get all my debt. Happy to give it to you.
But and to answer your question initially, if you start off and you have nothing when you start off, you can have a will, and it's a very simple will.
Right.
Directing everything that I own goes to my fiance or spouse or whatever else it is, and everything that my fiance has comes to me. End of story. Okay. Until you get something, and then you can make something a little more complicated as you get more assets.
Right. So we have actually a question from one of our panelists. Marcia, you had a question?
I do. Actually, it's regarding force majeure with regards to invitations or personalized items for a wedding or an occasion. If somebody should have an order outstanding, meaning that it's in progress, both parties have signed, and it's being in production, that production has already begun, what is the force majeure, or is there a force majeure clause that should be included in, per se, my contracts to protect me and to protect the client?
Sure.
Yeah, so Paul, I'm gonna defer to you on this one.
Well, so you're talking about invitations, correct? Like, let's say it's a person. Typically, if you've already started your performance, that means, so a force majeure clause, if you've already started and you're in the middle of it, meaning you've already expended, well, typically what would happen if you're in the middle and I call you and say, hey, this came up, I'm invoking the force majeure. What would happen would be you can stop what you're doing, you up to the point where you have completed your actions, you would stop. I would still be responsible for everything up to the point where you've started, but then I would be expected of you to not incur any additional expenses. So meaning, if you've done half of the invitations, then, and let's say I need 100 invitations and you've done 50. Okay, stop at 50 and then bill me for those 50 because you've already performed on your part. So the force majeure isn't going to kick in until the point where I come in, I tell you, hey, we need to cancel. So I'm still responsible for up to the point where you've already performed. Now, again, you can contract however you want. So if you want to put in there something that protects you the entire way, you can put that language in the agreement, meaning once you've started performance, the force majeure can't come in and stop you at that point, or vice versa. You can put in language if you're the client and say, I'm going to invoke force majeure, and if at any point, if I do not have a fully delivered product, and I've invoked force majeure up to that point, then I'm completely off the hook. It all is dependent on how you write the language in the agreement. But typically, if it's just a standard force majeure, you're going to be responsible up to the point where you've performed.
Okay, so if I had to just further that clarification, if the client has already put their order in with me, and let's say I work with another company who provides the production portion of it, and let's say they've already done the majority of the production, do I need to say in my contract with my client, do I need to say that force majeure is not do I need to use those words, force majeure, in my contract?
Yes. So, I mean, what if I'm understanding you correctly, if you're talking about your expenses with your own kind of a person who's a vendor to you. So,
yes.
in your,
I'm on the hook for it already. when I place the order. So if I'm on the hook for it, then how does it translate into the paperwork that I do with my client?
You essentially put into your contract with your client that, again, any expenses that you've expended upon this agreement prior to them notifying you of force majeure, essentially the force majeure is not going to affect that. I mean, there's pretty language you can put in there, but at the end of the day, what you're going to say is, look, anything that I've expended, if I've put in funds, if I've entered into agreements with other vendors pursuant to the services I'm going to provide to you, the force majeure is not going to affect that. Meaning, if I'm expending funds entering into these other agreements, you, client, are still going to be responsible for anything that I've obligated myself to for you. Now, what I would tell you too is, for your contracts with your vendors, you want to make sure you kind of have that tight force majeure language in there, because again, if it's like a trickle down thing where client comes to you, you have to go to a vendor, you want to be protected in those cases too. So in your agreements with your vendors, you want to kind of have that tight force majeure language in there as well for these types of situations. But I mean, short answer is, put in that language in there that protects you, even in the event of a force majeure.
Okay. So this is one of the things. Hold on, I get right to it. So here's one of the things is that let's just bring that down to a simple thing. Is that it sounded like you've got a couple of different types of force majeure. Force majeure meaning that you put in the wording that the force majeure, if enacted, means that the client is responsible for all the expenses that the vendor has then put out. Correct?
Correct. Up to that point of the force majeure, yes.
Okay. Sorry, Brooke, did I interrupt you? I'm sorry.
Oh, never. Did I interrupt you is the question, sir.
No.
This is why I get my own show on Thursday. Silence is not always golden. Going back to that whole entire thing, because I know how many times, like at the last minute, we're swiping that American Express, and I know how we do and how Keith Willard Events runs. But my question is this to you. I'm not trying to call you out. But like, do you have that in the contract? Because I don't deal with any of the legal stuff. Because I know there's many times at the last minute that we're doing things and whatnot, and I know the bill slides through somehow. But is there something in the contract that we have with our brides that that's there? Is it just something that thank God we've always we have honest people?
To be honest, as a entrepreneur, as a small business owner, I've always thought of contracts as kind of a handshake between two people. I always assume that contracts can get out. People can get out of it with the right kind of lawyer, that they can get out of it. And, so I do have a force majeure in my contract, but I'm gonna revisit my own contract.
That's
to be
what
honest.
I was like, ew.
I am definitely going to go revisit my contracts. So, Christine, when we talk about this, you've mentioned a couple of times, and that's why I want to go back to this. You've mentioned, and you and Wendy both have mentioned a couple of times, wrongful death. I'm not quite, where does that fit into all of this that we've been talking about?
Okay, so actually we had a case like this. We had a case where the couple went on their honeymoon and they were scuba diving, and he hit his head on some coral and died.
Oh my God.
Yeah, right after the wedding. Now, under that scenario, though, she would have some intestate rights because the honeymoon happened after they got married.
Right.
But say he just got into a car accident. And he ends up dying.
Yeah.
Maybe he gets into the car accident, he goes to the hospital, catches COVID in the hospital, and doesn't even die from the accident and dies from COVID.
Right.
That could happen.
Oh, that's interesting.
Yeah. So
I'd rather it didn't.
Right.
So,
oh my God.
And that happened before they got married. She wouldn't have rights to be the personal representative. Now, if the death happens after they got married, then she would have.
But is there a way to make sure, let's talk about wrongful death. I mean, I know that's a depressing subject, especially for people that are like, oh, great, I'm just tuning in, I'm talking about death. But is there a way to make sure that in the case of wrongful death, before somebody gets married, that your spouse, I mean, your partner, your boyfriend, your girlfriend, get what is coming to them for a wrongful death lawsuit? Like, are they able to then, is there a way that somebody could say, you know, we've been engaged for 2 years and then he was in a car accident. Is there anything in place that I can then sue the company?
Yes.
Does that make sense?
Mostly for the personal injury though. And you can name the person in your will to handle the estate and be the beneficiary of the estate.
Okay, so let me go back a little bit. So the estate can sue a company for wrongful death. Is that correct?
Yes, that's or they can sue a person. We do that all the time. That's a lot of our business. We get a lot of our clients from personal injury attorneys, and where the person's died or has become incompetent.
Wait, if I can interject for just a minute? The wrongful death is actually a statute in Florida, and it determines who can benefit from a wrongful death action. In order to have the wrongful death action, you have to have an estate. If you're not married before the wrongful death action, most of the time it's the non-married party, if there is documentation in place, can act as a personal representative for that individual, but they do not have a right to benefit from the wrongful death action. The estate may have a right to benefit from the wrongful death action, not the personal representative, not the fiance or whatever.
Right. God, that gets into a whole oh my God, that's crazy.
I have a question for the lawyers. If you
yes.
Okay, so we're gonna call this person Becky. So let's say Becky's been separated for 2 years, and she's moved on with her life. She's in love. She's having a great time. She has a new boyfriend, and COVID. So she's legally still currently married but separated, and all of a sudden she gets COVID and dies tomorrow. So what happens then, because I want to talk about power of attorney or something, to where Becky's future ex-husband doesn't get everything, especially her life insurance policy, and the person that she's with now gets it or technically maybe her father has control of that. How do you go about making sure, maybe Becky doesn't want her dad to have that anymore? She wants the new love of her life she's been with for 2 years to have it. How does that work out? Without napkins.
Okay. If I can start the process, the first thing that I would tell Becky to do in a particular new relationship, if the old one has in fact severed, but not legally, is like anything else, like real property, like anything else, the insurance, let her go to her insurance carrier and change the beneficiary. Okay. So she can change the beneficiary to her children, her fiance, her new boyfriend, her new girlfriend, whoever else it is. Okay. And that can be the beneficiary of her policy.
Now, what if she was forced to sign it over to maybe her father 12 years ago, and now she doesn't want that to happen anymore?
She can go back in, even if she was forced to turn it over to her father, she could still go back in to the insurance carrier if she is of age, which I'm presuming she is, if she's in this kind of a relationship. She's an adult. So she could go into the insurance carrier and say, I want to change my beneficiary. Period. End of sentence. Unless there is some legal impediment to her changing the beneficiary. And by legal impediment, we mean she has been determined incapacitated of some form, that she's in a guardianship or things of that nature. Other than that, she can change her beneficiaries.
Her name's Becky, not Brittany. So we're good on that.
So I should put out there, obviously, that what you're hearing, the advice that you're getting today is in general terms, and that if you have something specific, it's really important that you consult a lawyer in all things regarding contracts. Don't take what we're saying here and apply it without actually talking to some type of legal representation. Am I correct on that, guys?
Oh, absolutely.
100%.
Definitely.
Let's limit our liability here, because we are talking about some pretty heavy subjects.
Yes.
And and
Leave
obviously,
it to me. I can't
right?
throw a button, but I can push it.
Oh
And
my goodness. That's so funny.
And we didn't get to your other question, which is the power of attorney in Florida, which is where Christine and I practice. In
Becky
Florida,
currently lives there, so
Yeah.
a power of attorney only lasts during the person's lifetime. Okay, so if that person dies, power of attorney doesn't exist.
Oh, that's
Understand?
interesting.
And that also doesn't mean that a
don't
power of
die.
It also means if you give a power of attorney if I give a power of attorney to my husband and we divorce, and I decide to give the power of attorney to Christine instead of my husband, he doesn't still have it anymore.
Well,
I
I'll
can
have
change
questions
that.
about that. So.
Huh?
I'll have questions about that.
Yeah. And we'll ask,
After the
we'll ask those after the show, because we'll be able to still communicate after the show. So I'm going to go back to Paul. Paul, first of all, it's obviously important that you have a legal representation, like look at all contracts. Most people, I'm going to say, either are fearful of talking to an attorney, or don't know how to connect with an attorney, or are worried about the cost connected to an attorney. Can you help alleviate some of those fears, or even just like thoughts that people may have?
Sure. Well, first of all, most attorneys are pretty nice people. If you
Are they?
Contrary to popular belief. And a lot of attorneys, what they'll do is, they're not going to charge off the bat. You come and you want to talk to them, they'll give you some kind of consultation to see if, one, they want to take you on as client, or two, if you want to take them on as their attorney. And especially for things like this, it can seem scary, but it's really not, especially for somebody who's versed in doing this type of stuff every day. And, if you're scared about where do I find a certain type of attorney, the bar website for all the states. I know Arizona has a bar referral website where you can go and look up people. I'm almost positive Florida has to find a lawyer for types of attorneys there, or even a simple Google search. And quite honestly, too, I don't know of any attorneys who wouldn't be happy to at least sit down and talk with you initially to kind of go over these things, because it is scary. And when you see a contract, a 5-page contract in 8-point font, and somebody puts in your face, they sign it. I mean, if you're not used to doing it every day, it seems like a scary thing. And then most people think that they're not negotiable. So they think, oh, I just need to sign it. But yeah, I mean, hopefully, just even, like I said, a quick Google search, or go to the bar website of the state that, not necessarily the state you live in, but the state that you're going to have the event in, or the state where you're entering into an agreement with the vendors. Because, for example, if I'm doing an event in Colorado, but I live in the state of Florida, I'm not going to want to reach out to a Florida attorney. I'm going to want to reach out to a Colorado attorney, or vice versa. If I live in Colorado, I'm having my wedding in Miami, I'm going to want to reach out to a Florida attorney, not a Colorado attorney. Right. And, lawyers know other lawyers too. So if you even just know a lawyer and say, hey, look, I'm having an event of something, then your lawyer, if they're not a corporate lawyer or deal with contracts, I'm sure they'll know somebody who to refer you to. But yeah, I mean, it's not a scary thing. You shouldn't be scared or hesitant to reach out to a lawyer, to even just talk. And if you are really dead set against the lawyers, then, at least somebody who's versed in contracts. Like, for example, reach out to a wedding planner, such as you, Keith, who at least vendors. You deal with the stuff all the time. You at least know big things to look for without having to get into the legalities of it. So, I mean, I would say at bare minimum, do that. Hire an event planner, call you up, Keith, and say, hey, Keith, I want you to plan my event. Can you look over these things with me? Because you've been doing this long enough where you know kind of big things at least to look out for, even if it's not the small intricacies, you at least can steer the ship, so to speak.
I love Paul. Plug the host.
Right? I know, right? Thank you, Paul. That was awesome. Well, and that's true. And I think that a lot of people, this is very similar to an event planner. When people come to us and in the event industry, they don't know how to do the big event. This is a one-off. They're either a veterinarian or do something else. They don't do event planning, and so figuring out how to throw an event is scary for them. And for us, it's our joy, it's our passion. I'm assuming it's kind of the same thing for our lawyers on our panel today. Yeah.
Yes. Yeah. And the money that you spend can save you a lot.
Oh gosh, yes.
In all of our industries, I give
that to people all the time. I'm like, trust in your event professionals, because at the end of the day, they're going to end up saving you money.
Right.
It may feel like a lot now, but
and piggybacking on what Paul said, if you called Wendy and me, we would definitely talk to you. We talk to people all the time. Not everybody. Sometimes we know that it's just not going to be a good relationship. So, but and we don't charge for that. We,
right.
It's just the cost of doing business. So, yeah. I mean, there are some who do charge a fee to talk to the attorney, and then maybe they'll apply it if you hire them.
Right.
But a lot of the attorneys will talk to people just to get a feel for what you need, and it's worth. If you do end up hiring them, it's worth it, especially if something happens. It's like buying an insurance policy.
Totally. And I think actually that's a great place to wrap up this show. I mean, obviously we have talked about some seriously heavy stuff today, and we've delved into probably things that most people probably don't even want to think about, but it's important. It's important to protect yourself. It is important to protect your family. It is important to protect your fiance. And it is obviously very important to make sure that the contracts that you're walking into, that you know all the pieces and parts so that you're not in trouble later because of things like COVID, where you have to move a date and all of a sudden the venue is charging you 25% extra. So heavy subject, but I'm glad that we were able to hopefully disseminate some of this information. I do want to say a special thank you to Paul GrijAlva for your insight into the law, and as well as Christine Gill and Wendy Volcy. Thank you both for your insight into estate planning and obviously some of the legal. Thank you guys so much. You guys were amazing. Yay! And then it was lovely. And thank you, Marcy Gutenberg, with An Affair to Remember by Marcy. Katana Kaplan. I keep forgetting your last name every single time. I literally wrote it down this time. With a gallery of amazing things. Tyler Black with Cache Events. Unfortunately, Tyler had some technical issues, so he's been able to watch, but he's been like signing his questions to me. Not really. He's been putting it in the private chat. And then obviously Brooke Stoner. Thank you guys so much for being a part of the show. It was fascinating. Next week, next Tuesday, we're going to do a special edition of Behind the Veil, Happily Ever After, which is post wedding issues, and we're going to be talking to Dr. Jessica Bauer about IVF and reproduction issues, as well as Dr. Paola Radic, who's going to be talking about depression after a wedding, how to combat it, how to overcome it, and hopefully dispel some of those myths. Thank you again, everybody. Have a great day, and join us next Tuesday at 2.
Thank you, Keith.
Bye.
We love you. Thank you for having us. Give Wendy Becky's number, Keith.